Welcome to the President's Forum podcast. Today we have a great conversation set with Ken Nahigian. Ken is an organizer of the Balancing Act project, which was launched to help us navigate the massive changes that will result from the recent Supreme Court decision Loper v. Raimondo, which overturned the long-standing Chevron Deference rule. This ruling will have significant implications on the way that the federal government operates. In fact, I'd argue that this case is one of the most important cases in a generation. So we're thrilled to have Ken here to help us unpack the decision and what it means for our institutions and the broader regulatory environment. Hey, Ken, great to see you again. Thanks for making time to join us today.
Thanks for having me, Wes. This is really a great opportunity to talk to you.
Hey, I want to get us started on the Chevron doctrine. It's something that every law student has studied, I guess, since the 80s, right? And you were in law school and administrative law class. You probably went over the, Chevron Deference rule. And I want you to just start us out by telling the broad listenership in higher ed, what do they need to know about Chevron?
Yeah, I think it's really important to get the basics because this conversation's just been kind of thrown around. I actually find it fun that people actually know what this is now, because those of us who just knew it as this kind of this wonky legal thing, it was very complex for us in law school. But now people seem to know what it is. But the fundamentals are very simple, and I don't want to get all schoolhouse rock on you here, but our government is broken into three branches, and those branches each have a function. And Article 1, Section 1 of our Constitution is very clear. All the legislative and policy-making power is vested in the House and the Senate of the United States. And then the executive branch is meant to execute those laws. What's happened over time is that power has been delegated through a number of factors. But, 40 years ago, the court recognized you needed some sort of mechanism to try to interpret laws and give those agencies the backstop to be able to have that deference so that we wouldn't just get mired in illegal suits. And that was fine. It worked for a while. But we're kind of at a point where the politics have evolved so much that it wasn't working anymore for a variety of reasons. And, the Supreme Court just overturned it and put us back where we were in 1974. And, we'll see how it plays out. It kind of creates a whole new set of problems, but, the sky is not falling. I think the bottom line is that this is intended to try to reset our government and have a conversation about how our government is accountable to the people.
So the legislature, the U.S. Congress has passed a lot of different laws over the years.
That's right.
And the rulemaking process is in the executive agency has always been kind of a supplementary process to those laws where they get the laws and then they have to drill down a little bit deeper to administer them. And they've figured out, hey, this works and this works and this works. So we're going to do it this way. And reasonable minds could disagree with them. And in the past, what would Chevron Deference say in that when it goes to the courts?
Sure. I mean, so Chevron Deference would enable the agencies to defend themselves in court against the regulated entities that are challenging their suits, if they challenge at all. I mean, deference has kind of created a chilling effect where some of these regulated entities don't even spend the resources to try to challenge it because the deference is already assumed. So the agencies are starting on third base in a lot of cases in court. So that deference has been given to them. And the question is whether or not they're exceeding that authority and they're really going beyond what Congress wanted them to do to begin with. So removing that deference really just shifts this conversation to the courts. And if you look at Justice Roberts in his decision or in the decision with Loper, he's very clear. His point is that these agencies don't have competence to decide cases and controversies. That's very specifically laid out for the Article 3, judiciary. So it's kind of interesting. People have always looked at this issue as more of a push and pull with Congress, but the tension really at the Supreme Court is with the court wanting to take on these cases and not letting the agencies make these decisions. So it's kind of a reset of all three branches, and I'm excited to see how it plays out, to be honest with you.
Yeah. Okay. So you're on the front end of like figuring out how it plays out because you're one of the organizers of the Balancing Act project. Tell us a little bit about that project.
So over the years, regulated entities have not wanted to challenge their agencies that regulate them for fear that there'd be retribution, or they may already be suing that agency, or their sector is just one of many, so they don't have the ability to kind of effectuate bigger macro change as far as this is concerned. The Balancing Act project kind of recognizes that this is a wheel and that these sectors can't really get that type of conversation going on its own. So what we're trying to do is pull together a conversation across all the sectors, all the thinkers on both sides of the aisle. This is a neutral conversation. And I really hope that this audience understands that this issue should be very bipartisan, even though it's kind of sometimes couched as one side or the other. And it's couched through issues like higher education. Like, what's going to happen with this issue? This is a terrible court decision. Well, it's really more about resetting the dialogue about how do we legislate? How do we keep that power within Congress and accountable to the people, but then also prevent just a flood of litigation into the courts, which is going to create a whole new distortion in this process.
Right. Okay. So the project is meant to bring stakeholders together to work through it and share information and figure out, hey, this is such a fundamental shift in the way that the United States works.
Right.
We've got to work together to figure out what the horizon looks like for us.
Right. Right. So what are those guardrails? That all has to be worked out, Wes.
Yeah.
Everybody keeps asking, well, what's going to happen? What specifically is going to happen? Well, I think Justice Roberts did everybody a favor by saying that this was not going to be retroactive. There was a lot of talk about kind of upstream guidance being challenged. And I don't think that would have been fair because, agencies were operating under certain rules.
Right.
But, this is all prospective. And I think it's going to be very interesting. Justice Jackson in her dissent was, I thought made an interesting point. She said that this is going to create basically a tidal wave or tsunami of litigation. I think that's probably true. And so we're going to have to kind of figure out the role of Congress and get back to the art of legislating. One more thing, Wes, when I was up there and I worked on the Senate Commerce Committee, things were different. And we spent a lot of time working with our agencies. We had detailees for our agencies and we worked through technical issues to legislate. But we've gotten so much into this very kind of toxic political environment where legislation is kind of almost purposefully vaguely written and using agencies as a backstop. And I think that that's not going to happen anymore. And I think that's actually a healthy thing, no matter what side of the aisle you're on.
Okay, so I want to talk about just the influence that this will have on different branches of government, right? Yeah. So I'm just going to give you like the three branches here, and I want you to give me 30 seconds of what it means for, let's start with the executive branch. Give me 30 seconds of what this ruling means for them.
Well, I think everybody's unhappy in this situation, which is really interesting. And I don't mean about the decision, I mean before the decision. So if you are, let's say, a president who wants to use the agencies to effectuate policy advancements without Congress, you're probably not happy with this. If you're somebody who wants to work with Congress to get that agenda done, you're probably happy with this. This is going to make it so the executive branch has to be more careful about how it's interpreting major rules, major questions, things that affect a lot of Americans, $100 million or more.
I can think of a few of those in the higher ed landscape, debt forgiveness, anywhere in the finance, portion. I can think of, if I were to put all of our presidents together, we could probably think of 50 different things that originate in executive interpretation of the legislature.
Look, higher ed probably is the most affected because almost every single thing that's done in higher ed is done by regulation.
Right.
Everything from staffing to training to compensation to curriculums to you name it. So I hear you.
Okay, so let's move to the judiciary. What does the change mean for them, for judges?
Well, I think they're going to get a tsunami of cases. So I think it's going to really plug up our system and perhaps paralyze it. I think they're happy generally because judiciary really wants to decide cases and controversies, as is their right under the Constitution. So I think it's a positive for the judiciary. I think they see it as a reset.
So the judiciary is going to get to be more of the judge where the executive has been the judge.
Well, yeah, I mean, the agency really never was intended to interpret law. That's not a role of a federal bureaucrat. So it kind of puts the decisions back in, where they should be.
Right. Okay. Now tell us, if you were talking to a group of elected representatives or senators. Tell us what they need to know about this. What kind of responsibilities come back to them?
Sure. And I don't mean to sound didactic here, but legislators in general need to get their act together. The incentive structure for legislators these days under our current politics is to gain attention and then use that attention to leverage for a future opportunity. That's not how our policy making is intended to be. My message to legislators is to do your job, is to start really rolling up your sleeves and getting into the details of what it is you're doing and understand the consequences of that, because you're no longer going to have a backstop to kind of fill in the blanks for the laws that you're writing. You need to get smart, and you need to use organizations like yours to really understand the complexities of all these issues when you're making policy.
Okay. All right. So it sounds like, this rebalancing is going to take a lot of time at the federal level. Tell us about any implications to state regulation, if there are any.
Sure. A lot of states passed Chevron Deference laws in the aftermath of the Chevron case 40 years ago, and increasingly so. There has been a movement that has started long before this case by states to start rolling those back. The Chevron case in itself hadn't been cited in a while by the Supreme Court, and the states had pretty much abandoned it. So laws started pulling back off the Chevron deference standard in the states, and now there's a movement afoot to have model state laws that are being passed. I would anticipate, don't quote me on this, I believe 14 states have pulled back on those statutes. I'd have to check that, but more than a dozen have pulled back, and I expect a lot more to do so. And it's going to be the same effect. If you have state issues in state court, you're going to have this similar situation. The federal courts obviously will go up through the federal system.
So recently there was a negotiated rulemaking that impacted higher education pretty significantly, and there were a lot of comments. I think comments were due last week, and so there were a lot of organizations that were, putting in their final comments on this and the proposed rule. And I fielded a few questions from university leaders, from higher ed leaders.
Is this the gainful employment?
No. This has to do mostly with distance education. So there were distance education conversations going on, and state reciprocity was initially part of this negotiated rulemaking as well. And there are a few other concerning issues that we were following, but the questions that I received were really interesting. They were, a couple of them, well, more than a couple, a half a dozen folks asked me, now with Chevron being overruled, how do we frame our comments, and how much should we be thinking about what the legal repercussions are and what our options are? And they were just confused on how to address, this proposed regulation moving forward and future proposed regulation. So sure. I guess my question is, what recommendations would you give to higher ed leaders about how to engage in the rulemaking process and the legislative process moving forward with LOPR?
Sure. The Supreme Court had really been looking more towards what was called the Skidmore standard. I don't know if you're familiar with that. It was kind of a intermediate, kind of a halfway standard for deciding these interpretation cases. And under that standard, they were basically letting the agencies make the case for why their interpretation was authorized by Congress. I think we're going to go towards, we're going to have guardrails, right? And I think that when making those comments and being part of the rulemaking process, I believe now that you're able to challenge these rules, meaning a regulated entity, everything is going to be looked at. And I think it's a positive thing, because I think the more inputs, the more valuable, the more information, the more valuable. Maybe you're making comments about a particular rule, and you think that this is something that is authority being carried out from Congress. Maybe you should say so, right? Or maybe if it's ambiguous, maybe you should make the case for why this is as part of that rulemaking. Be part of it, knowing full well that this might get challenged and that the full record might be looked at, including congressional intent, statutory intent, rulemaking comments, et cetera, et cetera. We have APA, right? We have a process for this. And that was part of the ruling under Loper was essentially we're getting ahead of APA here. APA should be our process for comment, and engagement.
Right.
But still the agency should act under authority. So I would tell them just to be technical and be forthright and informational, and no longer think that this is going to be something that's just going to be, kind of shot through.
Do you anticipate that Congress will pass more laws? Do you anticipate that the executive will push things back to Congress and say, we need more clarification? How do you see that working?
Well, there's been some talk about the Congressional Review Act. I don't know if you're familiar with that, but it enables Congress to basically review agency rules, major rules, to make sure that they align with, what the authority was. But it's kind of a partisan mechanism. It doesn't really work. I personally believe we need a mechanism where on major rules, like, gas stoves, for example, we all own gas stoves. And all of a sudden, an agency decides they're going to ban gas stoves when Congress never authorized that. And that's kind of something we should be talking about if we're going to ban gas stoves.
Right.
It would kick back to Congress and have Congress say, hey, yeah, that's what we meant, and have an affirmative. A lot of states are going in that direction, and that might be it. But to answer your question, I think we're going to have better laws. And I think it's going to force people to actually do their job in a way that's meaningful. And I think it's going to give a lot of power to the experts on the outside. Things have become very neutered as far as the ability to receive technical information because they knew the agencies would be doing it. So the rulemaking became the place to have that conversation. I think you're going to find there's more ears to the ground listening to experts about technical advice. And I would really, really recommend to your audience that they get involved in a meaningful way and become those resources to Congress.
Yeah, it makes me want to recommend to our presidents and to other institutional leaders, hey, let's get more involved with Congress. Let's
100%.
give them more advice. Let's get more involved in crafting the specifics of legislation and give them our input on that so they get it right before it gets to any agency.
I was we work with a lot of trade associations. I was talking to one of them and I was asked the question, what do you think this is going to mean for us? And I said, are you kidding me? I mean, your association has been marginalized for so long because Congress wasn't actually engaging with you in a meaningful way. And now you are where the center of attention is going to be. You need to gear up and be a subject matter expert. I think it's going to make you more powerful.
I love it. Well, great advice. We will look forward to how this rolls out. And as far as the Balancing Act project, will you just keep us in the loop and let us know how we can learn more from the work that you're doing and where we can contribute?
Yeah, we appreciate that. We are a coming together of literally every industry sector and also any stakeholder involved here, including consumers. And we'd invite any sort of participation in this conversation. We'll have programming, and we hope to effectuate some results. Can I leave you with kind of I don't know if we're leaving, but can I just mention one more thing?
Yeah, please.
First of all, the fact that we're having this conversation, especially around higher education, where there's a lot of hot issues right now, as you saw yesterday by the Supreme Court. Ask yourself the question: when I moved to Washington, almost all of the legislative protests were at the steps of the Capitol, because that's where the policy decisions were being made. Fast forward, 30 years later, where are most of the protests occurring now, Wes?
At the Supreme Court or
Supreme Court.
Yeah, across the street.
That is a symptom of the problem. That's exactly the point. And it shows that this power has been delegated to the agencies. And that's all we're trying to accomplish with the Balancing Act project. Have a conversation. Okay, post Chevron, how do we want the world to look? We certainly don't want the world to look like everything now is in the judiciary branch. I don't think that's healthy for anybody.
Right.
But you have to remember, and your audience needs to remember, that the House of Representatives is where all revenue measures start. Why is that? Because
it's the House of the people.
Because it's closest to the people by design. And that's how far we've drifted away from that. So I hope this is a constructive conversation, and just would invite anybody, including your organization, to be a part of it. And I appreciate being on here.
Yeah, well, this has been a fascinating topic, and it's something that I think people don't understand enough about. When I was having conversations before this decision came out, I was telling some of our leaders, this could be legitimately the most impactful decision in a generation, because it'll impact the way of life for so many industries, for so many people. And
Yeah.
I kind of stand by that. I think it's one of the most impactful decisions we've seen in a generation.
Well, you're uniquely situated because you have a number of statutes that have been interpreted just a few words to do big things. And, that's where kind of the conversation is going to happen. Again, this isn't about being for education or not education. This is just about going through the right process. Like if you want to achieve X result, then just go through the process. It's not about being on one side of the issue or the other.
Right. Right. I totally understand where you're coming from. And the word balance is probably a very good word for this. We've got to figure out where each branch of government is in their lane and doing the things that they should be doing. I love the idea, actually, of being able to craft the legislation that we'll live by, that we have to abide by, and having that in the legislative process as opposed to an executive or judicial process seems preferable to me.
Right. And by the way, I'll tell you that you're not alone. I think the two sectors that are probably most affected by this are really education and kind of the climate type of issues, because both of those have been kind of those statutes have been taken and kind of used for a lot of purposes. And we'll just see how far those things go.
Yeah. Well, Ken, thanks for joining us today. We appreciate it. And I'd like to leave the door open for, as this develops, maybe we have you back on and we talk through, what this looks like a few months from now.
Sure. I'd love it. Thanks for the conversation.
Thanks, Ken.
Mm-hmm.